Good afternoon, everyone. Thank you for coming along. My name is Nicola McNeely. I'm a partner at HCR Law in the UK, head of technology sector team, and I'm your moderator today. So we're going to be talking to you about legal and regulatory evolution of NFTs, what's coming and what you can do about it. You've got a really diverse panel of lawyers here, all with different experiences, UK, Europe, offshore, US. So great panel. I'll allow them to introduce themselves, and we'll be talking to you about a whole range of stuff. So without further ado, I'll pass you to Dan Hyde. Thank you.
Thank you, Nicola. So I'm Professor Dan Hyde. I'm the cyber business coach at the University of Cambridge, and I'm also Professor of Digital Regulation. And I co-founded a company, Iconic NFT, which is essentially tokenizes, iconic art and artifacts. So I kind of wear two hats, one of them legal, one of them, I guess, kind of business strategy. I essentially commercialize NFTs and work with disruptive tech.
Hi, my name's Leon Hurd. I'm a lawyer based in London. I specialise in advisory and contentious regulatory matters with a particular focus on emerging and disruptive tech also. I spent quite a number of years working for an international offshore law firm, advising clients on regulatory issues in relation to their offshore structuring, and I was also a financial crime prosecutor for just under 3 years, working on a range of international matters, dealing often with law enforcement agencies around the globe.
Hi, I'm Sarah Shtylman. I'm a partner at Perkins Coie in our fintech practice, and I started, I guess, the crypto part of my career largely kicked off when I was the second lawyer ever hired at Coinbase. I did a lot of money transmission, money services work on licensing and AML-related concerns there. Glutton for punishment, I decided to go back to the billable hour model after making it in-house, and largely because I was so passionate about the expansion of the crypto industry, and I saw there were so many things that I wanted to be on kind of a lawyer, technology and payments nerd level I wanted to be involved in. And so I joined Perkins Coie about 6.5 years ago, and a lot of my practice focuses on kind of that intersection of payments and technology, with obviously a pretty heavy focus on blockchain.
Good afternoon, everyone. It's great to be with you. My name is Mark Cianci. I'm counsel at Ropes & Gray. I have my main office in Boston and also do a lot of work out of our New York office. I'm a litigator, and so I bring a particular focus that's emphasizing the disputes and how disputes are resolved, and in particular, I've been working on blockchain-related litigation and blockchain strategic advisory work for the past several years. Been in practice longer, around 13 years, and interested to hear what everybody else has to say today.
Great. So I'll pass you to Dan Hyde to talk about some of the regulatory stuff.
Thank you, Nicola. So first of all, look, hello, everyone. I think the title of the topic today is, the evolution of NFTs, what's coming and what you can do about it. But I think maybe we just take a step back and look at what NFTs actually are. So I'm certain everyone in the room has an opinion or has a view on, what an NFT is. But probably the better question is, what do the regulators think an NFT is? What's the legal definition? And that's kind of difficult. It's difficult because NFTs are, chameleonic, they're shape-shifting. They are essentially, sector agnostic computers with myriad use cases that can perform different roles in different businesses depending on how they're used. And that's important because it means that, that versatility makes them a very powerful tool of innovation in a business. They can add real commercial value. They can bring commercial success if they're applied correctly. The downside, or conversely, if you like, it means that they're also very hard to regulate and to legislate for because they're shape-shifting and chameleonic. Really quickly, what I'd like to do is, as best I can, give you, if you like, my tips or my view on how you might best safeguard or protect your NFT business going forward in light of current and incoming regulation. So for me, really quickly, before we even get to the regulatory piece, whenever I'm looking at an entrepreneur or a business at Cambridge University, there are essential ingredients that any, whether it's an NFT business or any other business, needs to have if it has any prospect of success. And it needs to essentially, solve a painful problem. So it's not just a problem, it has to be a painful one. And by pain, I mean one where the pain is so deep that there's going to be reward, because people are going to care enough about you solving that problem to make it worthwhile. The problem also has to be solved in a globally permissible way. And by globally, I mean, you know, every customer territory that you are targeting as part of your business, you're going to have to take account of not just the regulations, but also laws and local customs, anything that might potentially bring your business down. So the 4 tips I'm going to give you now, and I'll be as quick as I can because I know we have relatively short time, but these 4 tips, you know, they're not a guarantee, it's not perfect. But I think if you kind of abide by these, you'll be in a safer position. So the first thing I'd say, for like the golden rule, is deliverability. So look at what the core capability is of your business. You know, what's the core product that you're providing? And then you say to yourself, and can I, you know, deliver lawfully and reliably on that? So an example would be, let's say you are selling property, whether it's virtual property or physical property, and you're using NFTs for that. You've got to make sure that that's really tight, that when you are delivering that property, you know, there are not going to be ownership problems, there are not going to be intellectual property problems. So your core capability is deliverable. That's number 1. Number 2, performance. You've got to make sure that your hype, you know, doesn't exceed the reality. So your product needs to perform so that it matches the expectations of your customers. If it doesn't match the reasonable expectations of your customers, you're going to have all manner of problems. You're going to have contractual breach claims, you're going to have regulatory claims, you probably have consumer offense allegations as well. So make sure, as I say, that your messaging is in line with what you can actually perform in relation to you and your product. Thirdly, context. Context is everything with an NFT, because, as I said at the start, they're chameleonic. So look at what you are doing in the context of your business. Now, if, for example, looking at how your NFT is being used, it's behaving, let's say, like a financial instrument, so a security, a stock, a share, a future, or, you know, it all feels very much like some sort of investment scheme, chances are you're going to rub up against a regulator, you know, in whichever jurisdiction, and chances are you'll have difficulties because those activities are really heavy regulated. So stand back and take a look. And finally, before I hand over, the next tip is reach. What is the reach of your business? Who and where are you targeting? Because in each of those jurisdictions, you could have completely different problems. So a good example I like to give, and one that's actually a true example, something I dealt with very recently, a business, an NFT business actually, were actually targeting, they saw Dubai as being a promising jurisdiction. The problem is that there was a gaming element, or if you like, a gambling element, because it involved, and for gaming, by the way, all you need is a combination of you know, chance and skill, or a combination of the two for reward, and you're into this is gaming or this is gambling. And if you're in a place like Dubai, or effectively an Islamic region, chances are that's going to fly in the face of Islamic law, and your business can be taken down and you can be prosecuted personally. So those are kind of the 4 things I think: you know, deliverability, performance, context, and reach.
Thank you, Dan.
Thank you.
Can I pass you to Leon?
Thanks, Dan. And hello again, everybody. So I do an incredible amount of work with NFT businesses, helping them to establish compliance structures and robust governance frameworks. And actually, I don't think there's been a greater important time to get that architecture right. I often say to clients, nothing kills companies quicker than non-compliance. And I think that it's always an adage that's normally applied to traditional businesses, but where you're dealing with innovative sectors such as Web3 and NFTs, I don't think it can be underappreciated, because where you are dealing with innovative issues, the question of what is compliant or non-compliant is an incredibly difficult one to deal with. And so what essentially we find ourselves doing is trying to really understand the customer journey of a business, really trying to understand exactly what's happening with the crypto asset. And this is an incredibly important thing that we need to do. And as Dan said, crypto assets are, and NFTs in particular, are chameleonic. And what this means is that they've got this myriad of use cases, and essentially, you know, they could be used for almost anything. If you think about the metaverse, they can represent assets and value of all manner and kind. And this presents an incredibly difficult proposition for a regulator that's trying to structure a framework that can capture those different use cases. And I think the conundrum has been ongoing for quite some time, but it's really hitting the boiling point now because of a number of quite negative news stories, such as high-profile rug pulls, phishing scams, and of course what we've all recently seen with FTX and the demise there. And I think essentially we probably are at an inflection point in the NFT journey where I guess their mass appeal and their utility means that there has to be a focused effort on ensuring that they're also credible. And I think the real issue for all of us in this community is to really try and understand what's the regulatory horizon looking like and what are governments going to do to try and achieve that credibility. And I think that we're starting to see an answer to that question. Not quite a complete answer, but we are going in the right direction. I mean, the UK Treasury in February issued a paper, they issued a consultation paper where they set out their proposals and strategy for the regulation of crypto assets. And there are a number of really interesting takeaways. I won't go through all, but three that I think are worth mentioning are, firstly, there's going to be efforts to amend legislation so that crypto assets are included within the definition of specified investments, so that they are brought into the fold of the regulatory regime. But more importantly, and juxtaposed against that, there is a concession that we can't just awkwardly apply the laws. So where it might be a case that in applying the regulatory regime it stifles innovation, there will be efforts to improve that legal mechanism. There will be the introduction of disclosure obligations, and that's going to be a hugely burdensome issue, I suspect, because where you've got the issuance of tokens on regulated exchanges, you're going to now probably need to do some form of prospectus type document, and that will be completely new for a lot of the players in this area. But I think the most important point from my perspective is that they really make the point that they're going to regulate activities and not the asset. And I think what this means is that regulators are going to really need to understand really implicitly what is actually happening with the crypto asset and whether or not it is a use that falls within the regulatory perimeter. And from my perspective, I think that this substance over form approach is a positive thing insofar as hopefully we'll avoid just blanket regulation of crypto wherever there's a mention of it. But equally, it's going to invite a more intrusive and interventionist regulatory response, especially as they try to grapple with sometimes quite difficult NFT projects where they need to granularly understand what's happening and whether or not it's falling foul of regulatory issues. I think we're seeing the cycle play out globally. There are huge movements in offshore jurisdictions around vast legislation. We're seeing huge movements on the EU side with the MiCA regulation, that's the markets in crypto assets, which will bring in disclosure obligations, authorization requirements. There's a question about the application to NFTs, but I think the general consensus is that where you've got an NFT behaving like a security, you're going to be caught. Walks like a duck, quacks like a duck, it's going to be treated like one. And that's where I think we all need to get to. Again, with the UAE, they've brought in Cabinet Resolution number 111, which now effectively brings into fold any business that is operating a crypto exchange, operating a crypto brokerage, or holding and controlling crypto tokens within the regulatory sphere. And so I think the general point that I would make is that there is a global shift towards the regulation of crypto assets. And this is the reason I say global is because most NFT businesses, whether they know it or not, probably are global, whether that's because the key players that are running the business are in different jurisdictions or because the end users and consumers for which their products are put out there are in different jurisdictions. And so what I would say is it's so important to front load the regulatory issue and properly consider both current and imminent regulatory risks so that you can properly mitigate against them and put in policies and procedures to address it. And I think just before I hand over, my last point, which I hope focuses the minds on why it's important, is that I regularly work with lenders, VCs and investors, all of whom are alive to the regulatory headwinds that are coming. And quite frankly, those projects that front load that issue and build into their white papers or their business plans resilient approaches to deal with regulatory issues, they are more than likely to attract investment, much more so than those that just put their head in the sand and remain silent to it. So with that, I'll pass you on to my fellow panelist.
Thank you.
Thank you. So I'm going to focus a little bit on the payments angle since that's where a lot of my practice is, but I do want to underscore that everything my fellow panelists have said so far is great advice. So regardless of where you're located, equally true in the US. And so I don't want to, I'll give more airtime to the payments issues, but want to double down and double click on all of that as a theme. And building on that, I think one of the both blessings and curses that NFTs have is leveraging the same technology as fungible tokens. And I say blessing and curse. There's some blessing to not being kind of the first ever having to educate about what this technology is or what this technology does, but the curse is a little bit of you get kind of bucketed in. A lot of people start an NFT project and don't realize actually a lot of financial services regulators are going to be paying attention to what you do with your artwork or what you do with your ticket. And that's kind of an odd thing because, you know, in general, with some exceptions, financial services regulators aren't really first on the sort of radar of someone building a new ticketing platform or someone building a new way for creators to monetize their content. And so that is a little bit of a unique challenge that I think the NFT space has. And so when I think about kind of the biggest pressures in the regulatory environment that are either current or upcoming, one piece I will note, and this is sort of US specific, but as it relates to custody of digital assets, one of the things we're starting to see on the state regulatory level with financial services regulators, the type that typically regulate companies like PayPal and Venmo and sort of those Western Union remittance and peer-to-peer transfer systems, they're starting to, there's a trend with at least a few states, they're starting to say that if you are custodying digital assets on behalf of a customer, that is fiduciary activity. And that would require actually more than just a money transmission license, which is how PayPal and companies like that are regulated. It would actually require, at minimum, probably a trust company, if not a bank or heightened level of sort of financial institution. And again, it's only a few states right now, but there's sort of this, states often look to, well, what are other states doing for kind of guidance of how we should think about it? And so that's something that's been on my radar lately of like, oh man, how is this going to play out for NFTs if Nevada really thinks you need a trust license just to hold digital assets? Another trend in regulatory development is we're seeing a lot around CBDCs and stablecoins. And the reason I think that's important is because a lot of NFT communities are here to help people monetize, to help keep money in the hands of creators, to help keep revenue from tickets in the hands of performers and in the hands of venues. And so monetization and payments is a huge part of it. And a lot of the work that I do is helping clients bridge what they frequently describe as the gap between Web 2.0 and Web 3.0. And in that context, often the use of stablecoins is part of what they're doing. So there's some sort of, you want users to come in with their dollars, but at the end of the day, they can only interact with the smart contract with, USDC or USDT or whatever the case might be. So everything that I think touches and concerns CBDCs and stablecoins is actually very relevant to how we'll be able to sort of grow NFTs as a way for creator monetization going forward. And then the last sort of trend that I would highlight is what I will call quasi-regulation. And I could spend an entire day talking about this, but I think, again, focusing on the payments and how do we think about that for NFTs, I would put this in the category of not just how do you get a bank account when a lot of banks don't want to bank crypto companies, as well as how do you deal with payments on your platform when companies like Apple and Google require you to use their in-app payment systems and they take a 30% cut and they don't let you use any other kind of monetization. These are not, these aren't federal regulations that dictate these things, but they are sort of quasi-regulatory pressures that I think this industry is sort of in the vein of what's coming and what should you be paying attention to. So those are sort of the trends, and then when I think about what can we do about it, and this is going to echo a little bit of what my fellow panelists have already said, one big piece is educate. Whether it's educate the regulators or educating just sort of technology industry more broadly, it is important, I think, for companies like Apple and Google, as well as for banks, as well as for regulators to understand that NFTs often are very different from fungible tokens, both in their use cases and what they enable. And unless we do a good job of educating that, we run the risk of sort of this technology all getting lumped into blanket regulation and blanket legislation and needing to have a trust charter just to have kind of a custodial NFT wallet, which seems kind of like an absurd outcome. And so sort of educate as much as you can. Tell your friends, talk about it on Twitter, whatever your audience is. Help people understand that distinction because it's important. And I guess that also goes to the point of, to the extent you do have the opportunity to educate legislators or regulators, push for technology neutral solutions. And then the final piece of sort of what you can do about it is talk to a lawyer. The space is evolving really quickly. Lawyers in the legislative landscape not evolving quite as quickly, but the best thing you can do to protect yourself is talk to qualified counsel.
Thank you, Sarah. Over to Mark.
Thank you. And I'm going to go quickly because I want to make sure Nicola gets some time. So we've talked a lot about the legal evolution around NFTs from a regulatory perspective, and I want to add just a couple data points more from a litigation perspective, because that's usually where I'm bringing my expertise to bear. So there have been, and I'm going to focus in on just one issue. I had a few other points, but in the interest of time, I'm going to focus on the potential characterization of NFTs as securities. And this is only in the United States, because that's where I focus my efforts. The question will be dealt with much differently in many other jurisdictions. But there have been two interesting cases that have shed some light on A, the significance of the characterization of NFTs as potential securities, and B, how courts are coming to that decision. So the one case I'll talk about is the OpenSea insider trading case, where a user knew what NFTs were going to be posted on the homepage and then bought into those NFTs before they got posted, hoping that the value would go up. The defendant was criminally charged and late last year filed a motion to dismiss saying, well, this is not a security. These NFTs are not a security. Thus, I can't be charged with insider trading on that basis. The court rejected that argument and said there are multiple ways to characterize an insider trading case, and it doesn't have to be straight insider trading of securities. The court said the prosecution styled this case as a wire fraud and money laundering case, and wire fraud and money laundering can exist irrespective of whether something's a security. So from a criminal law perspective, whether the digital asset is a security or not does not determine whether there can be criminal liability. Then I'm going to shift focus to a civil case. We saw a couple months ago the court in Dapper Labs here in the Southern District of New York ruled that, at least for the motion to dismiss purpose, it was not going to push out a case that had been filed against Dapper Labs alleging that the Moments NFT cards were securities. The court, in addressing arguments by the defendants that Moments were not securities, said, well, if we look at the Howey test, which we all know, there have been sufficient allegations of horizontal commonality, of vertical commonality, of expectation of profits based on the efforts of others in this case. And so I'm going to allow this case against Dapper Labs to proceed, which when it first came out, everyone said, this is crazy, NFTs aren't securities. Well, now we have a case it's not definitive. It's not saying all securities, NFTs are securities. And it's not even saying these moments are definitively securities. We'll have to wait to get a judgment. But at least for preliminary purposes, we're going to allow the case to proceed. In the interest of time, I'm going to kick it over to Nicola, but I'd love to talk to anyone else after about additional details there. Thanks.
Thank you so much. What a diverse panel, and what interesting things we've talked about this afternoon. We've got literally a minute and a half, so I was just going to say, from my perspective, I act for a lot of NFT influencers and artists and creators. So I act for some of the Fortune magazine Nifty 50 and NFT 100. So I've been involved in this. Well, I've been involved in blockchain since 2013. I acted for the Royal Mint in creating one of the world's first stable coins, which was gold-backed token for payment and remittance, and that business is owned by HM Treasury. So I've been involved in this space for over 10 years. So I've seen the whole emergence of NFTs, pre-CryptoKitties and CryptoPunks and all of that. So I've seen it all happen. And it means I'm privileged to act for some brilliant people who are really ensconced in the space. So what I'd say is I help people with commercial agreements. I help them make sure they commercialize their NFTs. I make sure that they're regulatory compliant. And I also help them navigate the space because it's really complicated. So if you're looking to commercialize, if you're a creator, if you're an influencer, if you want to navigate the space and do it safely and do it legally, come talk to me. I'd love to talk to you more, but I think we're going to be told to wrap up. Any last thoughts really quickly? Anybody?
I'll be very quick, because the question was, what's coming, what can you do about it? So there's a slight dilemma, because if you're going to be entrepreneurial, you've got to be brave, but that bravery has to be kind of tempered by precaution. So yeah, of course you've got to take risks. That's the nature of the game. But do it in a measured, precautionary way.
Nothing further to add, really. Take a calculated risk by coming to see lawyers like us who can help you. Right.
Great.
Think we're done.
Thank you, everyone.